Welcome to Feminism Today, everyone. I'm Sophia Johnson in New York. Last month, a synagogue in South Florida sued the state over its abortion ban, citing a violation of Jewish people's religious freedom. Experts say this is just the beginning of what could be a wave of lawsuits from religious groups. A common thread relevant in recent developments here is also the influence that anti-abortion religious institutions like the evangelical Christian Church, the Catholic Church, and others have wielded in building political support for new and more tougher restrictive laws. For more on this, we're joined now by Caroline Mala Corbin, professor of law and Dean's Distinguished Scholar at the University of Miami School of Law. She specializes in religious freedom and the Constitution. Professor Corbin, welcome to Feminism Today.
Thank you for having me.
So, a lot to unpack here. Your research focuses on the First Amendment's speech and religion clauses, particularly their intersection with equality issues. Does religious freedom protect a right to an abortion?
So that is exactly the question being litigated now in the Florida case that you just described. So Florida has passed a law that bans abortion at 15 weeks. And some Jewish synagogues are arguing that this law implicates religious rights, both the right to religious liberty and the right to have church and state separate from each other. Under Jewish law, the pregnancy is considered part of the woman's body until birth. It is not a separate entity until then. Moreover, anything that jeopardizes the woman's well-being, including a pregnancy, ought to be eliminated. So there is actually, under Jewish law, a mandate to eliminate pregnancies that can harm women physically and mentally. And so the religious liberty claim is that banning abortion, even in the situations that are religiously required, is a violation of their right to practice their Jewish faith. Mm-hmm. In addition, there is a separation of church and state argument in the lawsuit. The argument is that claiming that the abortion ban is ultimately premised on the idea that life begins at conception.
Right.
But this is a view of pregnancy that is not shared by all religions, and particularly not the Jewish faith. So the argument is that it's one particular religious viewpoint that's being imposed on everybody else. And that is not what should happen when there is separation of church and state.
Right. Now, another common thread, as I mentioned in the introduction to this recent development, is the influence that anti-abortion religious institutions like the evangelical Christian Church, the Catholic Church, and others have wielded in building political support for new restrictive laws. Do you see this as problematic? And how should religious groups sort of look at this issue? What do you think is going on here?
Right. And so I suppose I anticipated your next question, which is, what kind of influence is one particular religious tradition wielding in terms of our laws vis-a-vis reproduction? And I think there's very much been a codification of a certain conservative Christianity into the law. And I think this is obviously highly problematic. I mean, not just from the point of view of religion, but from the point of view of women's lives.
Right. Now, there's some who might argue that America is a Judeo-Christian. It's the founding fathers were Christians. Should that factor into, how should people who have made this country their home sort of feel about what the rules are and how the rules have been established?
Right. So one of the foundational principles of the United States is that all religions are welcome and everybody is allowed to practice their faith up to a point, but it's supposed to be religious liberty for all.
Right.
And that means that all religions are welcome, and the law should not be sort of imposing one particular law onto everyone. And so the Constitution makes no mention of religion. Judeo-Christian is not really a thing. As we see, the Jewish law is very different from Christian law when it comes to abortion. But the main point is everyone's religion is welcome, and everyone should be able to live their religious truth, which is no longer possible now that we have constitutionalized abortion bans.
Mm-hmm. Now, some experts say this is really just the beginning of what could be a wave of lawsuits from religious groups. Should the courts expect more pushback? What will this look like? Can we talk a little bit about the religious groups quite possibly forming an ally for the social good in terms of rights?
Absolutely. I expect we will see more lawsuits challenging. Now, again, if you're just focusing on abortion bans, there absolutely will be. I think there will be another one in Ohio, also brought by religious groups, but I know that they are seeking allies. I was just on a program with the rabbi spearheading the lawsuit in Florida, and he was very explicit that he was open to forming alliances with any other religious organization, any other religious group who also felt like their religious independence, their religious rights, their ability to live their religion was jeopardized by this wave of abortion bans.
I want to pivot a little bit, and because you are in Florida and because you are so embedded in the discourse here, now across the United States, at least a dozen states are considering a new controversial legislation that in several ways will mirror Florida's law. The Florida HB 1557, also referred to by some opponents as Don't Say Gay. The specific details regarding the bill varies from state to state, but overall, they seek to prohibit schools from using a curriculum or discussing topics of gender identity or sexual orientation. I wonder if we could talk a little bit about what's going on here.
This is an appalling law on so many levels. It's clearly motivated by people who are anti-gay and anti-trans and are just not comfortable with anything other than heterosexuality. That's not a legitimate basis for deciding what education students have access to or not. And so it's true that the state has some measure of control over the curriculum, but ultimately, their decisions can't be based on hostility to unpopular ideas, and certainly not based on hostility to unpopular groups. So that kind of litigation is problematic both under the First Amendment right to free speech and also under the Equal Protection Clause, which bans discrimination against certain protected groups.
So let's stay on this for a moment longer. Supporters of this legislation say it's really meant to allow parents to determine when and in what way to introduce LGBTQ plus topics to their children. It also gives parents an option to sue school district if the policy is violated. The governor, Ron DeSantis of Florida, remains defiant in the face of critics. What do you think? I'm trying to sort of peel away the layers. Is the position that he's taken for his states in terms of education policy sustainable? Is this a winnable case by opponents of this bill?
Well, as we see now, whether a case is winnable or not ultimately depends on the judge that's deciding it. Should he win it is a different question, and the answer is absolutely not. Again, there's the idea that parents have the right to dictate curriculum is simply not sustainable. You can't have parents have the right whether or not to send their child to public school or private school. But once they make the decision to send their child to public school, they no longer can exercise veto power over what is taught. I mean, imagine that you have someone who does not believe that the earth is round. Are they allowed to are they allowed to say that science class can't teach basic science?
Yeah.
There are just some topics that children should learn. And the basic idea that there are lots of different families in the country is really ought not be controversial.
I mean, another piece of this as well, I'm sure you're aware of it, the Trevor Project. The idea, the studies have shown that the LGBTQ plus youth already face higher health and suicide risk. And, you know, I'm wondering to what extent this can be factored into consideration, and if this would be evidence that would be brought to the courts in terms of why this law simply doesn't make sense.
So I think there are legal arguments to make and policy arguments to make. I'm very well aware that LGBTQ students are often at risk. And one of the things that exacerbates that risk is hostility towards them. And for trans kids is not having their gender affirmed. And these laws are trying to erase their very existence by not allowing discussion of their existence.
Right.
So I certainly think as a matter of policy, they're horrendous. But even as a matter of law, as I said, they should not survive challenges because they really are curtailing speech for illegitimate reasons. And second, because they really are the result of hostility towards the LGBT community. And those are not acceptable grounds for laws.
Mm-hmm. So much ground I want to cover with you. But thank you so much for sort of weighing in on this issue. We've had other guests sort of speak to it, but what you're sharing in terms of legal perspective is certainly well appreciated for our audience. Now, some time ago, pivoting a little bit, you published a paper in the Boston Law Review. The article articulated and argued for a new First Amendment right, the right against compelled listening. And I want to dig into this a little bit. You're smiling, so I'm
very long ago that I wrote that.
Yes, very long ago. But I dug it up and I thought this would be interesting. The questions that I'm posing are sort of the questions that you presented at the beginning of the paper. So let's talk a little bit about what is the right against compelled listening? What were you really trying to get at with this paper?
Let's see if I remember. It was about 10 years ago, wasn't it? I got my start in reproductive rights. So I think partly what sparked it was these mandatory abortion counseling laws that states require, that they claim is about informed consent, but is really nothing of the sort. It's really about the states forcing doctors to parrot their pro-life ideology. And so my question was, is there a First Amendment claim for patients? Now, clearly there's a First Amendment claim for doctors because the free speech clause has always protected both the right to speak and the right not to speak. So just as the government cannot censor what you say, nor does it have the right to force you to say messages that are against your own beliefs. And again, I'm speaking very generally, there are all kinds of caveats to this.
Right.
And so the doctors certainly can have a claim against sort of states forcing them to tell patients things that are really not helpful and perhaps not even true before they're allowed to have an abortion. So that would be the doctor's free speech right. Yeah. And I was trying to imagine, does the patient have a free speech right? And part of what the free speech clause does is, while most people think about it as the right to speak, a lot of the free speech is about the right to hear and the right to receive information. So when people talk about the marketplace of ideas and how free speech is supposed to protect a marketplace of ideas, it's really not protecting so much the speaker as the audience. It's like your right to get whatever information that you might find helpful, which is, for example, what plays a role in students' rights in schools. They have a free right to receive information. And so in existing free speech law, there is both the right to speak and the right not to speak.
Mm-hmm.
There's also for the audience a right to hear information. And I thought, well, perhaps there's also a right not to hear information in terms of free speech, if you're focusing on free speech as sort of affirming your autonomy with regard to receiving information. So just as you should have the right to receive information that you would like to, you should also have the right not to receive information when you're sort of a captive audience, meaning when you have no choice but to be somewhere.
So then isn't this, sorry, go ahead.
Yeah, it's like, so for an example of that might be like a student in school whose coach is praying, right? Maybe you have not just a religious right not to have to be forced to listen to a religious exercise. Maybe you also have a free speech right when you're sort of stuck in the classroom, that you shouldn't have to hear something like your teacher praying.
But isn't this what Ron DeSantis is saying?
It's not in the doctrine. This is just that was just me playing with. That was just me playing as an academic.
But it is compelling, though, and I wonder, if isn't this what Ron DeSantis and his administration is talking about in terms of LGBTQ plus, sort of this "Don't Say Gay" bill? Is that where the argument is leaning on? Are these the arguments that this legislation is leaning on?
I think the argument they are more, I think the constitutional right they are more focused on are not the rights of the children, but the rights of the parents. Because there is this right of the parent to sort of control the upbringing of their children. And so to the extent that he's invoking other rights, I think it's that one, which does exist, although it's not nearly as powerful as he claims it to be.
Right.
So don't you go blaming me for Ron DeSantis.
I'm not. It just occurred to me in this conversation. When I was doing the research, I was actually thinking about something entirely different. I was actually thinking about, can the state require employees to listen to a diversity training lecture about
that was one of my other examples.
That was your question about the necessity of embracing and celebrating gay and lesbian lifestyles, for example. And I wonder if you could talk a little bit about that, because diversity and inclusion is a big department on university campuses, in the academy all over this nation, and really indeed around the world. So what then of this argument here in the United States in terms of diversity and inclusion?
Yeah, so again, I just want to make a distinction between private employers and public employers. So if you're a private owner or a private school, you're not actually subject to the Constitution. The Constitution only applies to things that states do. And so only the state can violate the Constitution. So I think it's always important to make that distinction when we're talking about what can employers do or not do, or what can schools do or not do. Private schools are private. They're not subject to the US Constitution. And then if you're talking about public, there's actually a whole complicated doctrine if you're talking about schools, like what can they make their teachers do or not do. Teachers don't have quite the same rights as employees as they do as citizens. So there's that complication. And so can the government make people attend diversity training? I'm pretty sure I said, yes, it's fine. I'm not quite sure. Again, your employer can make you do all kinds of things that the government as an employer can make you do things that the government as the sovereign or as the government can't make you do.
Yeah.
So the government as the sovereign can't make you be polite to people, for example. But the government as your employer can require you to be polite to the customers who come in, if you work at the DMV. Right. So, it's
thank you for that distinction, though, because I imagine people, especially our demographics, the people who watch the show and tune in, they're all over. They're in urban areas, they're in rural areas, but they're people who are weighing in. There are lots of people trying to figure this out. And I mean, as an academic, you know this all too well. Students come in And if some of them are familiar with the literature, some of them are familiar with the discourse, and people, whether they know it or they don't know it, people are trying to weigh in on something that is really sometimes really above their head. So I value this sort of insight because it's helping viewers to sort of understand the dynamics at play when we try to legislate something.
Yeah.
Or, you know what I mean?
So if you're at a private company, I'm sorry, you have no free speech claim.
There you go. Now let's talk a little bit about feminism and the First Amendment. This is a show about, exploring equality of the sexes, what this looks like, what advocacy and activism looks like. First, feminist theory has at times challenged traditional First Amendment doctrine by emphasizing theories of equality over free expression. Feminist theory argues that women should enjoy the same rights as men. I don't know if you know this name, Phyllis Schlafly, Schlafly. She is a conservative author and activist and is best known for her successful 1973 campaign to stop the passage of Equal Rights Amendment. Does it sound familiar?
Phyllis Schlafly, who's notorious for helping defeat the ERA by scaring everyone into thinking that we would no longer have segregated bathrooms.
Right. So I wonder, do you feel that feminism has made any contribution to American life? Phyllis had a different sentiment about this whole space. And as someone who has sort of studied and looked at this from all sorts of legal perspectives, what are your thoughts on this?
Well, obviously, feminism has made tremendous impact as we now have the right to vote and we now can have our own credit cards and own property in our own name, which was not the case 100 years ago, or even actually I should say the 70s was when I think women first got the right to have a credit card in their own name. So obviously it has made an impact. But that doesn't mean that we don't still have very, very far to go. I mean, even gains that we had made before, as in reproductive rights and reproductive justice, we're seeing setbacks. So my answer is, of course, feminism has been crucial. Without it, I probably would not be sitting here talking to you. At the same time, there is still so much more to do. Even in areas we thought had been resolved, like access to abortion. And I fear actually we may see more retraction of reproductive rights in the immediate future.
I wonder about the validity of gender roles. Do you think are gender roles valid?
If your argument is the idea that women should do certain things and men should do others valid, I would say no. I don't think so. I think that there are, even take the whole thing underlying so much abortion law is the belief that women should be mothers, and that is the appropriate role, and any woman who rejects that role is unnatural and should be punished. And if women dare to have sex, then they should accept motherhood as a consequence. In fact, that is really the only reason to have sex. Like, that is one view. That's ridiculous. Some women want to be mothers and will make great mothers, but some women are not interested in motherhood. And some men are amazing parents. And if you have two parents, one man, one woman, it may be that the father is better suited to being the primary caretaker of the children as opposed to the woman. And that's, of course, assuming that your couple is a man and a woman. It may well not be. And so do I think there are God-given gender roles that we are obliged to follow? Absolutely, positively not. Moreover, that belief should not be imposed on us who do not have the same view about what our roles should be.
Now, I want to know if we talk a little bit about race for a minute. In 1959, for example, African Americans were more likely to be married than whites were, but now it's the reverse. And I'm just wondering if you have an opinion about that.
I think you cannot, right? The you can't define a person simply. A person is both, can be a gender, you have race, you have religion. These are all different aspects of our identity, and they all play a role in how we experience the world. And again, I'm focusing a lot on abortion because that's so much in the news and very much on people's minds. And I think that the consequences of the restricted access to abortion and probably the increased policing of women's bodies that is sure to follow, that burden is going to fall disproportionately on women of color. And so I think it's really important to acknowledge that. And I think we really have to redouble our efforts to try and fight that consequence.
I wonder if we could talk a little bit about what advocacy and activism should look like in an era where we have not yet quite settled, at least in the United States, this question on religious freedom, constitutional rights, and particularly their intersection with equality issues.
I'm sorry, the question you're asking, I missed the...
Right. So my question is, what should, as we sort of think towards...
what should we do about the disastrous situation we currently find ourselves in?
Right. So what should advocacy and activism look like in an era where we have not yet quite settled on, at least here in the United States, on this question of religious freedom, constitutional rights, and particularly the intersection with equality issues? What does advocacy and activism look like?
You know, I've been asked this question repeatedly, and I wish I had a really good answer, and I haven't figured one out yet. Clearly, part of the problem is that those in power are not representative of the people who are affected by their laws and rulings. And so I think one thing that really matters is increasing representation at every level of government. That includes the executive, that includes legislatures, and that includes courts. Because I think if we had courts that look more like the American people, and legislatures that looked more like the people they were elected to represent, then I think we would more likely get the laws and court rulings that would respect the wide variety of people and would more likely reflect what people believe. Because quite honestly, a lot of the Supreme Court rulings we've seen do not reflect the majority of Americans. And a lot of the laws that are getting passed are not laws that the majority of Americans or people in a particular state want.
Professor Corbin, Professor of Law and Dean's Distinguished Scholar at the University of Miami School of Law, thank you so much for joining us this week.
Thank you.
And that's it for our program today. Remember, you can follow me and the show on Instagram or Twitter. Thank you so much for watching Feminism Today on Free Speech TV. Join us again next week.